Yes, I have seen something which is beyond RFP.
The question is discussed.
We have read that,
Set aside the
that they cannot take recourse to something which is not provided there.
For judgment item number 22316 of 2025.
set aside, but directed the authority to proceed.
Revisit.
Notice of that.
Judgment item number 3, WPC
I was smiling face.
WPC 1134 of 2026.
Set aside the chairman's view and the cancellation of tender we have set aside. And follow up actions. And return this. File document or will.
No, we'll have to, yes, there is a file which has to be returned.
So file.
Give it back. There is a blue round of blue
File.
at the bottom.
Containing the
file.
file notings.
You take that.
We have noted it, some portions we have noted in our judgment.
Do it. File is there. You just give it, hand it over to us once. At the bottom, it is there. Let's call the next.
You are the returner, no?
Yes.
You are engaged. You take it.
To be mentioned item number 4.
This has been done for clarifications which we want. The reason being, while dictating the judgment, what I noticed was that your argument was simply hovering around, that is also before the regional authority as well as before us, on the applicability of the explanation which has been appended subsequently by virtue of an amendment to 21. Your contention is that it is a declaratory or clarificatory in nature and therefore have a retrospective operation. That's the only argument which you advance. You have cited 2 judgments which I have taken note of. But while going through the papers, so far as the revisional authority, revisional application is concerned, we find that there is a plea which has been taken by you relating to IBM's decision allowing or permissible variation is permissible to the extent of 10% or a 20%. No address was given. I do not find whether there was any document which was annexed with the revisional application or not. Would you like to argue that particular point before us, or would you like to abandon that point? Then we will have to proceed and dictate the judgment. Because I find that in a revisional jurisdiction, this is what they took. What we're talking about. This is what. coming home. I've seen a common judgment, the coming home. I've seen a common judgment, the
One second.
Locum has kept it open.
You know, para 136, that's exactly our
I
case.
understand there is a reflection you have taken in your original application.
Yes, Your Lordship, but
But
yes,
no argument was advanced.
not dealt with it, Your Lordship.
No, sir, you did not, even before us, you did not argue. I could have understood that you argued this matter before the revisional authority, they did not consider it at all. But you also did not argue that particular point before us. No, you did
Yes,
not argue.
I did not argue here.
So-
Your Lordship.
Give me that act. 21(5). No, not this. Section 21(5). When you get all this,
Your Lordship, give us 2 weeks time, Your Lordship.
the justice is paramount, so no point should be left undone. Something has emerged from the record. Really.
Have you got any,
Provision of law. Sure.
Also cancel. Petitioners are all, they are exempted from the filing court fees. Our law is my law.
Sir.
No, I have. In part of government, in part of government bank.
Sir, where you have claimed for exemption? Where you have claimed?
No,
You have to say, you have to prove by documents that you are coming under this category.
all the petitioners,
Exempt.
all the.
Sir, where you have stated, where you have given a proof. This is not an automatic exemption you sought for.
Even if I have paid court fees,
Where is the relevant documents in support thereof? We are saying that I belong to a member of the scheduled caste or the scheduled caste will not do.
all are.
You'll have to give a certificate. Claim an exemption. You can't do that.
I'll
I do not want this document.
I'll file court fees, you will also kindly say about me.
If several persons join together, file one petition for a common relief, or one relief, similar relief, identical relief,
I'll file.
then whether is there any provision available in any statute that separate court fees are to be paid.
I've gone through, but
I got one judgment for you.
Right.
That one I got. Saying in the similar lines. But I don't find any statutory provision here.
I also do.
Do you have?
Sir, there must be a provision relating to a fixation of a court fee on a writ petition.
Well,
Has to be. The court fee cannot be charged without any statutory backing. Don't allow Mr. Raj to go, the senior advocate. He should come. Are you aware of the procedural provision, Mr. Law? The court fee cannot be levied without any statutory provision.
cannot be.
Is the fiscal,
That's the fiscal and has to be.
so it has to be. Where is the provision relating to court fee to be paid on a writ petition? There must be either under the rules or under the Court Fees Act.
Yes. 6 rupees for kilo, 6 rupees.
I know so far as the Calcutta High Court and the West Bengal Court Fees Act is concerned, I am aware. But what about here?
But must be based on Court Fees Act. Court Fees Act, Court Fees Act, 1870.
There must be a schedule.
Yes. Court Fees Act, Schedule 2, Article 1. I can just.
Please show that what it says, because the question arose here, which is rampant everywhere across the country. This is
Yes.
not a new phenomenon which I could find here. That there are several persons who are joining together and filing a writ petition. 18, 20, hundreds, sometimes 200.
Yes.
I have come across. The question that arose, that firstly whether these kind of a writ petition is maintainable, it has been a consistent view. Joinder of several persons in one litigations having a common cause of action is permissible.
Subject to payment of
So
independent.
far as a court fee is concerned, it is to be charged individually. So for every individual petitioner,
Separate court fees have to be paid.
I do not know that the language is like that.
Yes. That
What is the language here
the such.
in our state here?
That immediately I'll have to just verify and tell you about it. But you have got that judgment.
One judgment, Sarpangal. WPS 4668 of 2016. And 4669 of 2016. The division bench that is pronounced on the 10th February 2022. Similar discussions were raised. The first paragraph itself shows, and their lordship.
What this judgment is cited by you, sir?
Joint petition, maintenance of joint petition.
Where it is said?
My lord, lordship, I is page 4, my lord. Page 4. Last 4 lines.
I do not find any page 4. You are started the page 89, 90.
That is another case recorded, page 92, lordship, can see 90. The page,
Yes, which one?
last paragraph.
Yes.
In the counter filed by the respondents, two preliminary objections were taken that the joint petition filed by the petition is not maintainable in as much as it is involved determinants of different procedural facts based on separate cause of action. And that the petitioner have not added as a respondent to all the officers who would be adversely affected by any order to be passed by this court. The rule in question are justified on the ground that they were validly passed. It is stated that offending clause cannot be thwarted.
There is no decision on that. I have seen.
Next page, while I'm
We are not impressed. That is not a real, where it says about the court fees.
The fourth feature.
Sir, there is, yesterday also I indicated, we have no doubts that it is not maintainable. Several persons may join together. That is the spirit of the photo procedure as well.
So separate court fee.
Even a joinder of a several cause of action into one, joinder of several parties into a one is permissible.
Yes, number two.
And here also, petitioner number 7, you see,
17.
she doesn't come within the fold of this.
All are women.
notification.
All are women.
No, there is
All are women.
there is no, submission there to seek for to be tried for seeking exemption. It is to apply its mind when it comes to.
So you give another chance, I think. Right.
Rejection of a plaint like a theory, Order 7 Rule 11. If you do not put in the court fee, reject it. How much court fee for the writ?
Six would be solid for some.
Six, you know, should be. Sure, matter is going to order. Yes, who is for the other side? Steps. Unit number 2 to 4.
For the opposite but not 5 million.
Any objection?
No, man.
Matters will settle, we have to wait out the decision.
Item number 7.
May I please? In the case where, despite having been issued with a LOI, the tender was subsequently cancelled and I have
You're challenging the order of blacklisting.
both cancellation of tender and blacklisting because it's a composite order. By the same order, both the things have happened. Now let's
Then.
right.
Yes.
Now let's
Very good order.
that's annexure 1 month. Page 14.
Non-submission of the securities along with the bank guarantee.
Yes, madam. That is the ground taken. Though as far as the security deposit is concerned, it was deposited
Beyond the time.
beyond the time and as
For
far
an
as,
extension.
sorry, ma'am. Yes, I had sought for an extension on the ground that my son was hospitalized and medical certificates to that effect had been furnished. Well, it's, I'll just, as far as the other part is concerned, that's the bank guarantee. There was a 45-day window and that window was still available. There was a 45 days window and that window was still available. Now, before I be further, let me show your lordship
What is
the tender condition.
Tender condition.
Yes, madam.
Relating to security deposit.
Yes, madam.
Tender condition.
Yeah, lordship may straightway come to page 32.
15 working days.
15 working days. The LOI was issued to me on the 20th of November,
Just one week. LOI.
was issued on the 20th of November 2025. On the 15 working days expires on the 9th of December 2025.
Yes.
On the 7th of December 2025, I requested for an extension of the ground that my son was hospitalized in Kalinga Hospital, and medical certificates to that effect were also provided.
Yes.
On the 12th of December, on the 16th of December, I paid the security deposit.
According to you, there is a
Delay of-
9 days.
5 days, 5 working days delay was there. And my lords, what happened there? This money was paid.
Is there any power given for extension or is there any provisions related to an automatic cessation or a cancellation?
That is not there. That they have to pass an order terminating. That what the contract says that if I do not pay, they have the option of terminating.
8F.
Okay.
If no, if B, four, 8, 4.
In the event the tenderer's failure after communication, that's at page 32. Communication of acceptance of tender to furnish the requisite security deposit under clause 8(1)(a) by the due date on requisite security deposit to the foreign bank guarantee under 8(1)(b) and 8(1)(c), including extension period. So there is a window where they can extend.
No, the extension then is clarified as applicable only to a bank guarantee.
Bank guarantee. Bank guarantee, that window was still there, 45 days. His contract shall be summarily terminated besides forfeiture of earnest money, and the corporation shall proceed for appointment of another contract.
And subsequently, period of 3 years, 3 years is there, subsequent.
There any
As far as the bank guarantee is concerned, if your lordship sees C2, in case of failure of the tenderer to deposit the bank guarantee as stipulated in clause 8, so and so, within 15 working days of acceptance of his tender, further extension of 15 working days can be given subject to levy penalty at the rate of 1% of the whole amount of the security deposit. Another 15 working days with levy of penalty at 2% of the whole amount of the security deposit. Managing. So with penalty, that is 8C2, page 32. In bold, it's provided in bold.
that is in relation to bank guarantee.
It's in relation to bank guarantee. So as far as the sequence of dates are concerned, well, there's just one more date which I would like to give your lordships. 27, 10.5.4. If, however, a request is received from the contractor for extension of time for submission of the SD, the same may be considered in exceptional
Just-
cases on merit and
just
actual
one minute.
time may be
Just 1
considered.
minute. Which one?
10.5.4 at least.
57.
Actually, 10, it should be 10.6.4. I think it's a typographical error. It's a typographical error. Should be 10.6.4.
What is this document?
This is also annexed by the opposite parties.
No,
And the
this
same
talks
thing-
about chapter 10. So that's why I'm just asking.
Sorry,
Page 35,
35, yes.
which contains this, it talks about chapter 10. So what is this chapter 10?
These are, I believe, the CVC guidelines. Because they have also annexed the very same document as annexure E by 1.
That is not forming part of the standard document.
We annexed the bank guarantee extension, not in this security deposit.
Very clear security deposit, very clear that
No,
it talks about security.
extension in respect of bank guarantee is there, but not in respect of security deposit. That was
This is what
specific.
it is.
Very same document is also valid.
No, this chapter 10 emanates from,
CVC guidelines, CVC guidelines.
the cover page is not.
Sorry.
This cover page is not there. This document, post chapter 10.
Does it form the part only the common data?
No, my lords, it doesn't. It doesn't.
So does the tender conditions stipulate that any standard format or a general terms and conditions will be embodied here?
No, it is not there. It is not there.
How can we give a reference to this?
Sir, as it emanates, this version is December 2020 during pandemic. So is there any possibility of change of scenario and subsequent guidelines? We do not know.
No, but the very same document, if your lordship sees, and it's shared 3/1.
So for the purpose of pandemic, they might have issued this.
And documents that is extension bank guarantee. Some of these things.
So
Yes.
Might be order.
Your lordship may kindly take paragraph 11 at page 8 of the counter affidavit. They admit that there was a possibility of extending it, but
Where
at
page?
page 8 of the counter affidavit, paragraph 11. Page 8, paragraph 11. Your lordship has that? That in reply to para 10 of the
No, I
present treaty.
understand, I
It's
understand, but
relevant.
how they are, whether it is applicable?
They say that,
Oh,
they
they
say,
never made any request.
yes.
When you made a request for.
Kindly see, my lord, page 21. 21 is my representation.
Page 21 and also page 26 also there.
भैया वो सारी चीजें अपन बोले नहीं ताकि तो
Best one is it? Upon supplement profile.
मैं सप्लीमेंट फॉर्म में
I'm supplementing your submission. Page 21 and page 20.
Let him speak.
Trend is very
He
clear.
is taking an exception. Let him speak.
I'm helping him.
your lordship sees page
712.
712.
That is the last day according to you.
No, 912.
912
912 was the last day.
So before that,
Yes, and your lordship over the page, your
No.
lordship sees at page 22.
is there any dealing of this?
No,
Have
no, no.
Have they received it?
They denied in the counter affidavit that they have not received.
Then where is a proof of dispatch of this letter?
My lords, that is not there.
Then how can we?
That is not.
Somebody says that it was.
Fact remains that the time expired on the 9th. I made the payment on the 16th.
Beyond that.
Beyond the time. Beyond the time. In between, there was no order emanating from the opposite parties, terminating the. There was a bank transfer. The money was credited into their account on the 16th. On the 17th, at 8 p.m. in the night, the impugned order has been transmitted. At page 29. Kindly see.
No, I understand, but we'll have to, once they.
Yes, my lords, I
deny,
into that.
once they deny, then we'll have to say that it has been.
It has been, sir, I have said that
This
I have
statement is factually incorrect,
it was hand delivered in the office of the opposite party.
but there must be a seal or something.
Unfortunately, there is nothing.
No,
So, my lords, if your lordship will
it's a
now take
question of oath versus oath, then who is to be believed? believing you will tantamount to disbelieving him.
I fully understand that. Now, if your lordship will kindly see, now the point is here, the point that I'm trying to make is that till I made the payment and the payment was appropriated by them on the 16th, there was no termination of the contract. Now, my lords, if your lordship takes page 29, by which the impugned order
There
was
is no representation dated 16/12.
1612. 1612, we made the payment. That is at page 27.
This six at PGS, eh?
26 is the representation.
No, 27 representation is also given.
26 and 27. 26, the 6 is the
Yes.
covering letter.
Yes, they are talking about this.
Yes.
They are talking about 16.
1612.
You will
1612,
find at the bottom the seal.
it was received.
So how can they not put a seal in 712 letter?
Right. Now, what I'm trying to make is here. My lords, kindly come to page 29.
You notice this.
Kindly come to page 29, my lords. The impugned order, communication of the impugned order.
Twenty.
29.
Yes.
This is the mail through which the impugned order was
They
communicated.
understand. They talks about the letter.
No, your lordship
Yes.
sees the time, date and time of communication. It is 17th of December
I
at 7.
understand at 7:44 p.m. attaching the office order of 1512
Yes, my
and a
lord.
letter of 1612.
Now kindly see that office order. That's what makes it even more suspicious. Annexure 1 at page 14. Kindly see the office order. The office order is dated 15/12/25.
Yes.
Now, over the page, at page
Signed on 12/12.
12/12. Now, why this mischief? Obviously, a mischief has been perpetrated.
Last circuit.
Why was this manipulation made?
And also pointed out that.
Well,
I've already
then
that.
how if a letter is dated 15/12,
No.
can it be signed on 12/12? At least 15/12 or latter. So the birth has been seen on 15/12. Can anybody sign before the birth?
No, not that. Lordship can see my reply to that. Also requested Lordship to answer this page 6 of my reply, my counter. Well, of my counter. This is not missing. It is official procedure. So see, 12 is the order passed by the managing director. Doctor can paragraph 8 of me.
On your counter.
I'm reading that. Yes. Page 6, paragraph 8.
Yes.
Of course, no pleading was there in his read petition. Of course, no pleading was there. Still, I answered this point. I'll read my letter. Second paragraph is the relevant. First.
Very interesting, sir.
Sir,
Is it a usual and ordinary practice?
sir, yes. Sir, in 730, yes. Yes, my
This
lord.
state,
Yes.
I have seen many letters also.
My lord,
Signing on suppose 10, but the first page of that letter.
Yes.
That is
Issue date.
number.
it's very unusual, even if it may be a practice, I have not come across such a practice.
That's why.
Why does
It may be, but, no, my lord.
Just that question. So I have seen many official letters and circulars also.
No, but it's what makes it all the more, I leave it to your lordship. But what makes it suspicious is this, my lord.
Because
Prejudice.
that if an authority has put a signature on a particular date, how come the issue date becomes the subsequent date, not on the same day? That is what. But here I have seen many official letters and all, and circulars also. The authenticated date of suppose 10, the issue date can be 12th or.
No, that is a different matter altogether.
No,
That is a different matter. My lord, let a gazette notification. It is signed, thereafter sent for notification. Obviously, the notification will happen at a later date. It cannot happen on that date.
Now here that, so that's what.
So this is not a gazette notification. This is a letter which was sent in person. Now, my lords, what is important? Why, my lords, it becomes suspicious is this. On 16, I made the payment. They say the letter is dated 15th.
15th.
It is dated 15th. Let us assume it is dated 15th. Why was it communicated on 17th at 7:30 p.m.? Kindly look at the chain of circumstances, my lords. That's what makes it suspicious.
Entire read petition, there is no such pleading is there.
There is absolutely no.
You got this question. See,
And when you
the managing director put the signature on 12th. Then subsequently 13 and 14 is the holiday. Then 15 is the issue. Then subsequently general manager.
That is something very innovative.
That
It
is
is something very, I would say, surprising.
that
to
is
me.
no, that is true. That's
There's a letter
but in her
which contains the serial number signed by an authority 3 days before, or a 2 days before, or a 1 day before. But it bears a day at the top of a letter.
so as I explained, say 2 days holidays were there at 7:30.
I'm
That's
again
correct.
saying,
Yes,
the
yes, correct.
signature is put when the letter is produced before the authority. An authority, after going through the content of the said letter, put his signature. Or the authority dictated the entire order, and then it is transcribed and placed before him, and then he's put his signature. The letter in usual and ordinary sense must bear the same date when it is
That is
made. When it is made, it does not depend upon a issuing date. Issuing date will come at the bottom of the letter later on, that by virtue of this number, correspondence number, the issuance date, which may be different. I have come across from a state where memo contains the communication in the part
That is correct.
when it is communicated.
But what happened here?
But the letter must bear the same date on the same date when it is signed by another.
What happened here? Here at 7:30 he put the signature
If you
and
come to page 28, you come to page 28, you are on document.
30.
You have put here the same thing. which,
28, yes.
What is there? 28, page 28. The issue date.
Second half the general manager. Yes.
Signature is 16.
So that is what is to be done.
Yes.
Normally, in ordinary sense, it is done. I have not come across a single instances. My brother has an experience, I can't say, maybe a possibility, but I have not come across there a single letter which is signed by an authority before the date of the letter.
But he explained under what circumstances that wasn't done.
Sir, I have
That's correct.
there is issuance. it may be, there was no difficulty. It may be at 12, you may have communicated on 15, 16,
I will
17.
not deny your
It's
lordship's
different.
assertion. My learned friend,
Yes, sir.
in fact, what happened, my lord, to learned friend, in order to escape from the real fault he has committed, he came to this line. Lordship
The
can,
real point is what?
not that's correct.
What is the applicability of chapter 10 which is relying?
That's correct. Lordship, but,
Tell me what is the applicability?
may I bring to
of chapter
lordship's
10?
one document, he himself also, Amit Lordship can see page 26. He said that extension time was short for, he said that extension time was short for, it's a totally false affidavit. False affidavit. Lordship can see page 26. Can you that is own survey. Page 26, yes. He said that the extension time 7/12/2025 is short for an extension. I'm reading madam. On the subject cited above, it is informed that we have deposited the amount such and such at TGS on 16/12, that is beyond the cutoff date. There he said, and 50% security deposit such and such is due to an unforeseen medical issue. Neither we had intimated to you good of this or nor deposit sale. So 7 letter is totally false. That's confusing. He himself has his own document. He said that never intimated. In order to escape from these default clauses, he came to this. So, my lord, this procedure, in fact, how to produce, lordship, see, it is a PDS system. In a tender, commercial tender, time is the essence. When was a corporation, in fact, what he did for the poor people, grades to carried out by the HCI. In our Godam, HCI people are depositing this grains.
I had quoted a lower rate. Now they have given to ad hoc
Maybe.
contractor
Maybe.
at a higher rate.
Maybe, but the violation of contract.
It's a loss to them. Had they given it to me, they would have made more money.
The violation of contract is telltale. You also admitted that.
And there is a substantial difference. It's an ongoing contract for 3 years.
That too, RTGS
In perpetuity, they will be suffering a loss.
He never intimated us. RTGS also sent the money after cut-off date.
So my question is not answered.
That's correct. This
What-
signature.
Whether chapter 10 applies or does not.
On security deposit, it didn't deposit in time. That's not.
I'm simply asking.
Extension clause is not there in the
Sir, I'm asking chapter 10 when he refers to 10.5.4 or 3. Whether this particular chapter 10 is a part of tender, not a part of it. That's the only query I have.
No, this is not the part of it.
It applies, my lord.
That way, extension that in respect of bank guarantee, it can't be a security deposit.
This is what they talk about bank guarantee. They talk about security.
That is very much in that way. Tender documents. When was there? He sought for an extension, but in fact, he subsequently denied that. Yes, he didn't take any.
Of the counter, you have stated
In which paragraph of my writ petition? Paragraph 10. Para 10, my lord. Para 10 of my writ petition at page 7. Humbly submitted here that as per the Central Vigilance Commission guidelines as mandatory for tender management, wherein particularly in submission of security deposit, it is categorically stated in clause 10.5.4 that if request is made by contractor for extension of time to secure a deposit, then the same may be considered for granting additional time. In this situation, without considering his genuine requesting on the ground of medical emergency, terminating the contract with punitive action of the authority is unreasonable and unsustainable in law. Then I've admitted, which they have replied at page 8, paragraph 11.
Yes.
Not denied the applicability of that particular chapter 10. But you have interpreted this clause 10.5 that it is only applicable when any application seeking extension is filed before the expiration of the period. That is the your only contention. Does it appear from this clause that it has to be filed?
Why
Does it appear from the language? If you look at 10.5.4, does it talk about an application prior to the expiration of the period?
Lord, my submission to my lord. Also see, in his CBC submission, I replied in paragraph 11. We said that he never requested.
Sir, I am again, sir, you are accepting the application representation to have been made on 16/12. Correct?
Accepted this,
You have
but
accepted
that amount.
received. Let us forget about 7/12, sir. Forget about 7. You have admitted that it has been received on 16/12. You have received.
That is RTGS, but in fact, that is written.
Representation for extension of time.
Yes.
You have accepted, admitted in your conduct.
Yes, 16 received, yeah.
Now question is, suppose if we do not consider 7/12, 16/12, he asked for an extension. Why not 10.5.4 will apply and you have to take a conscious decision.
But he has not come with a clean
Does
hand.
it say that it has to be done within 9th December, not beyond 9th December? Does it say that it cannot be entertained if it is filed after the expiration of the initial period provided in the NIT? It does not talk. It simply talks about that on a request, extension can be done in an exceptional cases. And that too by recording reason and approval of the competitor. So that is required to be taken into consideration. Why you will not take?
But in 16 Malad 30s, his letter, he said that he has never requested and these are the things happened. But subsequent after 9th Malad, he deposited that amount on RTGS. That is also without the approval of the managing director and the authority.
Sir,
That's correct. Lord,
It
it's
is
correct. I
wrongly
only
done. It is wrongly done.
that.
This provision invites your attention to take a conscious decision. You may agree, you may not agree to extend. You may reject it.
That you said
On record,
that in our
rejection.
in our letter, he said that yes, you have never requested under
The
16.
only thing is that the consequences are harsh. When the power for extension is also provided.
Power for extension, no, sorry, no. Power for extension in respect of bank guarantee, not for security
Sir,
purpose.
your paragraph 11 of your counter, you have not made a distinction, sir. Your contention is that during the original period, he never asked for an extension. He asked for an extension by giving a representation on 1612, which is beyond the original time, and therefore the authority cannot invoke this provision. This is your stand.
That's
So,
but apart from paragraph 11, earlier also said that in fact
now the
8(1)(a).
question is, the question here raises a doubt that whether the termination was actually issued on 12
Actually,
or 15, because the communication is made on 17. He wanted to take, he understood what he wanted to say. He said that if the termination actually happened on 17, my representation was there on 16, how can you proceed and pass the order? This is what he wanted to present.
Because by the time 16th letter was there, Malad, by 12th already termination was there. So Malad, in fact, what happened, Malad, here, that is not in the pleading, that 12, 15, 17, all these aspects, Malad, this is afterthought. That was not in the pleading. Since last occasion, since worry that
These are all apparent.
that's true, but to the how is
What is apparent from the record can be not
that
seen.
is how
Let
it
us see, but applicability of this clause is to be there. You have not denied the applicability.
that is
What I can gather from paragraph. Left to
with regard to
consider,
that.
reject, whatever you want to do it, it's your baby, but you can't.
And only one point is that whether that is CVC is applicable to this or not, that is
Sir,
not.
what are you talking? I am reading paragraph 11.
Paragraph 11, because he himself is in his.
Sir,
Yes.
in reply to paragraph 10
Yes.
of the present writ petition, it is relevant to state that as per CBC guideline, now you are saying clause 10.5, it is stipulated that, then you have quoted. That shows that you have not denied. Then, in the present case, the petitioner never made any request seeking extension for time for submission of the security deposit within the stipulated period.
Yes.
Either in the form of a draft, bank draft or a bank guarantee. Nor did he intimate the opposite party about his medical emergency prior to the expiry of the prescribed period. Then you admitted, on the contrary, as stated by the petitioner himself in his representation dated 1612, due to unforeseen medical issues you quoted. This admission unequivocally established that no request for extension was ever made within the permissible time frame. So, what does it mean? That there is a permissible time frame
15 days.
within which extension can be sought. So, extension can be made if it is done within the time frame. Then it requires the applicability of 10.5.4. Because the NIP does not contain any power for extension.
No, with regard to.
Only in Bangalore.
Let's say the correct. What happened in that CBC, my lord, what happened? That's correct.
Your statement.
No, our statement in fact, but.
Sorry, you can't.
Just like.
This would.
I do not want to make any comments. How a document which is non-existent can form part of the accountable service.
Admit 7 plus votes.
Oh, the way of drafting a counter. A document which is non-existent according to you forms part of the counter evidence. Annexure C1.
Coming from there, this.
I have not come across to be very bad.
Sometime thereafter or in close proximity also. And you are enclosing this letter 1612 also.
1612 we enclosed, no, no.
Both letters you have enclosed.
That was the part of his rate petition.
Sir, that is indicative, sir.
We replied in respect of two documents.
Is it a correct way?
Right.
I am asking you, sir. When you are raising a very, very serious allegation that it was never, sir, it was never communicated.
Right.
So existence itself is doubtful. And then you are relying on that document.
Visualize why you are annexing two documents. We want to compare the two documents that he committed.
That is already there in the petition.
Maybe there,
form part of your-
but our answer will be, my answer is, my lord,
It is not your document. How can you make it a true copy attested?
like true copy attested means, my lord, that he himself said that he
Sir,
extension sought for, then subsequently said that never extension sought
Come to
for.
paragraph 21. Sir, you are a senior advocate.
Maybe that's-
I'm taking. Come to paragraph 21. How you have verified the entire statement. Tell us. What? Or paragraph 121, you have said it is true to your knowledge, derived from the record. Then this document must also be derived from the record.
Yes, yes.
So,
Derived from the official record.
the official record contains.
it takes part of the official record. It was there in your record.
We just stereotype for paragraph.
I do not know, sir. When it is drafted, there should be some kind of a.
Normally in all counter
No, you will not go into
stereotype for
that.
paragraph official record. But in fact, madam, my
But
solution.
whatever in fact, but we will
And
go
that's
by the pleading. We go by the pleading, sir. The officer must take responsibility.
But my lord, in contract condition itself, there is no question of any extension of that. Major lord.
Item number 8.
Your lordship takes up the matter, there is a small error in the order. Yesterday's order, which I would like to point out to you. It has been recorded as FRP certificate. There's nothing known as FRP certificate. FRP is fiber reinforced plastic. Certificate, my lord.
That's exactly what has been written in the opposition. I did not counter activity. That's why my lord has observed.
Just one.
So,
Para 5. Para 5E. Or yesterday. However, it was clearly it's pointed out by the learned FD Constitution of India that it is not the FRP certificate which is required to be submitted and forms the basis of rejection of the bid at the technical stage, but the FST certificate, which is paramount and mandatory. There is nothing against FST certificate. What is the certificate which is required, my lord? If you just point this out and I'll take it. My lord, so your lordship may see the specification.
I think that was the only thing, is that the FST certificate was only submitted in respect of the two aspects.
Yes.
But not in respect of the.
But with humility, if the railway doesn't seek a clarification, which is producing the.
Why we got it in paragraph 5, that FRP certificate, because the rejection says technical certificate and then says not in terms of the RB Railway Board letter.
What
Really talks about the certificate. Where is the document?
Yes.
This minutes from the pleading part. They have used the word.
Because there is nothing in the FST certificate.
But what we have.
That is what I wanted to point out.
We are very conscious when we use any word or expressions.
Please.
You see, if you come to the,
Yes.
1.1.
That says what certificate?
You please, sir.
Why for?
All technical certificates.
For, yes. L1 and L2 and.
For petitioner, already we have filed the documents by way of affidavit on that day. For L1, L2, there is 3,200 pages of entire documents. For the relevant person, we are on the process of downloading the same. It took some time. And we have downloaded the relevant person what required by the court. That's why the seal cover I have given to the court.
No, I opposing. Well, I tell you, lordship, why?
So you can act upon here. We have there must have some limitation to submit my lord.
Look, I don't.
They're indicating something was it is very unfortunate.
Look, I don't want to get aggressive.
Well, 1.1 and they are not challenging the same.
Because there.
Initially, the petitioner was challenged. There is no paragraph about the L2. Again, after filing counter, they have finally amended. We have accepted yes. Because
I will be able to show that they have not complied with mandatory railway circular.
yes.
I don't know how.
How can it be
I don't need to get aggressive here. If that is what has been given to the court,
Let Latsima examine this document.
that's it.
Let us see the document first. It has been given. An argument cannot be thrown
We can't just raise south and it's not like that. We'll have to be very cool and calm while arguing the matter. It's not the way to south intercept and get the matter resolved. It's not the way.
No, I am not shouting.
And those marking all things. Step by step, let's see.
The mutual respect to each other here.
Two to sets. We will have two sets, man. N1 two sets, N2 two sets.
We got the solutions L1 or
L1.
L1.
You are taking L1 and in first page it may not be planning materials man. The first page. Paneling. First paneling. That was not with the petition. And which is Vedanta is given. Next, authorized paneling legitimacy after.
Next is OEM.
That is their certificate is not with this document. Authorization 1. With authorization 2 is not there. Authorization 4 is there. Authorization. It is not so.
So it does not relate to any kind of a testing report to be done by any authorized agency.
That is not required. What is requirement? Requirement.
May I just now, just,
Just from the tender.
may I just get benefit?
In the London DSC. Don't jump. Let us understand. What is
Nasim is keeping the.
all those.
Nasim may take this. Yes. Nasim may keep the record of Vivada
Of a
L1.
private individual, you submitted. Is there any stipulation that it has to be done by a recognized panel testing laboratory?
No.
May I answer that?
Yes, yes. I'm here to answer. Don't worry, I'm slow student.
Stipulation.
My lord, that's why the entire penal engineers are present here, entire pages. They will apprise the court, but I'm just giving the rough idea and lordship will whatever document they have given.
Private laboratory and they are doing it something. So I just wanted, because we are concerned with the paneling. We are
Yes.
not concerned with the epoxy or something.
Or wash machine.
Because there is no dispute.
Here it is
Also
doing-
submitted it.
Yes,
There is no
the materials which are supplied by any of the company, suppose X company will supply to the railway. The contractor has submitted document that I will fix up this, that is this, whatever document is disputed, it is for wall and the roof. The floor they have already given, there is no dispute. So what happening is in the railway, suppose somebody has taken some cigarette in the bathroom, they put the cigarette in that wall.
Sir,
This just quality they have used in the time of manufacturing sale, that quality must be fetched with the technicalities was given by the competent authority. This is the issue here. Suppose X quality.
we are not really going into that.
Mine.
What appears to us from all these conditions which have been put into a tender document is to ensure that in case of any fire, maybe from a cigarette butt, which is prohibitory.
Yes.
Nobody would be permitted to smoke in the railway apartments or
Or the even to toilet also.
coach. in the
Yes.
railway,
Yes.
or on the station.
Yes.
There is a complete prohibition affecting the prosecution.
Yes. Yes.
Right.
Yes.
There may be a multiple reasons.
Yes.
It's not a secret, but only.
Many anything also.
There must be a electrical short circuit.
Yes.
That may also happen.
Yes.
Because then in that event, the material must be of such quality
Yes.
which would sustain up to a certain degree or of a centigrade
Yes.
of a temperature,
Yes.
so that it may not spread so wide.
Exactly, man. Yes. Yes. Let's see rightly catch it. Yes.
Common man.
Yes. Yes. My lord is rightly catch
There
it.
is no difficulty.
Yes.
This is for larger public interest. And there cannot be any second thought that there would be any compromise in this regard. Nobody, no sensible person would say that you compromise on a quality. When it is in relation to an avoidance of a casualty to happen.
Yes.
The question is that
Yes.
what it means. You have said that these testing reports are really an FSC.
Yes.
The fire, smoke, and toxicity
Yes.
resistant. These are the reports submitted by some individual or a private the testing laboratory.
Yes.
Is there any stipulation that any testing report from any kind of a test laboratory is acceptable to the authority, or the testing report must come from a recognized, authenticated,
NABF.
and then authenticated, impaneled testing?
Yes, such a stipulation.
Yes, my lord, this company would suppose the X company will given them, we will use the Tata. For example, I'm saying the Tata will give the certificate to the railway. What is the? I'm giving example. That company, particular company.
But company, when he certifying that what is the sanctity of such certification, then what is the purpose of securing the certificate? What, that it should be some authenticated laboratory who should submit, and the testing has to be done by them. I'm simply asking this.
That is there in the tender condition.
May I?
Put your lordship, put your lordship. It's there, it's there. It's there.
Just I'm
Where
passing
is-
this.
it's there. Just take it, your lordship needs.
Safety has-
Testing lab has a facility.
That is the railway document I am providing. This document, Lordship may see.
Look, this is part of the tender document, technical eligibility criteria, testing must.
Reputed lab, like you have already said, it is a part of the tender.
Yes, yes, part of the
Yes.
tender.
So you have said like
Yes,
Exova,
we have not filed, but it is with the railway document.
CSV, UN, whatever.
Lordship may come to 5.4.
Look, could I get a look at what has been handed over?
Reading
I have the-
5.4.
Yes, ma'am.
So you have identified reputed lab like Exova, Rapid, BNB, UV, Nord, Warrington, Fire, or any other lab of international standards having the requisite accreditation for carrying out this according to Indian ISO or IES 72035. In absence of any of the other detail, the offer of the firm should be considered unsuitable.
Unsuitable. That means whatever certificate will giving that by company, again it will be certified by this independent, this organization, whether what this certificate data used and the certificate given by them is rightly given or not. That will be again independently tested by
Your lordship's query.
By whom?
my lord.
It is to be individually tested by whom?
There is these organizations, my lord.
Any of these.
This will get it tested.
My lord.
Who will get it tested?
Original equipment.
Original
May I?
original equipment manufacturer.
OEM, original equipment manufacturer.
When?
Before bidding on fitment one.
It is before bidding, after fitment.
Before fitment.
Before bidding, again after fitment. That means before bidding it will be given a one certificate. Again after fitment and time of delivery, then give a certificate. It should be tested by the independently by the railway, the particular organization they have chosen by. There's a different category of testing system by which whatever their certificate or testing laboratory they have given, we can certify ourselves.
Ignito has been incorporated here.
Yes.
I do not find from this clause 5.4.
It is their document. It is only L1 document. But this document, what my lordship required about testifying whether it is rightly testified or not. Am I correct, my lord, in this one?
Sir, I am asking very simple question.
Yes, yes.
Clause 5.4 would have named certain tests.
It is.
I do not find that this laboratory of this is substantially included there.
Could I know I'm probably crossing the threshold, but can I just get the court's attention for 2 minutes and answer this query that you also will put into the learned DSG? The circular is on record. She's not answering it. There's a circular of the railway saying for fire testing of 4 and 555, you have to get it from 4 railway approved laboratories. Page 22 of my rejoinder. And serial number 1 says EN 45545 for fireworthiness complete repair, which is why I'm not getting slightly
Excited.
yes, excited because the
Lord, my instruction is the certificate given by Ignato is one of the approved laboratory by review.
Where is that approval?
Ignata approval.
Where is that?
We give that approval, that's there. It's one of the approved laboratory. Page 22 of the rejoinder. It is there. Is there, page 22 of the document.
yes,
The clause of the penalty is reduced, the clause shows. One has in mind. Ignito, I do not find.
It is one of the.
But there is one.
Lordship, doubt is correct, my lord. They will clarify this.
International reputed one is also given.
Yes.
So,
Whatever.
the parameter of.
The railway can clarify it in its railways approved laboratory. The parameter is at page 176. Page 176 of the writ petition, the parameters are set forth.
Mr. DSG,
Yes,
my brother has noticed some other thing.
yes, madam.
From the writing of your officer, referring to clause 5.4,
Yes.
at the top with the marker what you have written. What you have, give it to him. Give it to him. With
This
the
paneling and
what? No, sir, on the marker what you have. Handwritten, it is not printed. At the top. What? Why you have written a wash basin?
they have one paper is a wash basin, another is a paneling. Like the internal.
No, that should be very careful. The clause and your officer. It is the one
They should give a lordship paneling.
Madam, just act like.
They should give that paneling.
I'm not misguiding whatever document we have. My lord, what I am saying, my lord, those documents were submitted to the court with respect to the L1 and L2 is submitted.
Simple question, sir.
Yes, ma'am.
You are referring clause 5.4.
Yes.
Which says that these specific laboratories must issue the certificate you have named. Exova, you have named some certain organizations with another omnibus clause or of any international repute. Confirming a particular specification. I do not find the name of Ignito.
It's there.
Now, what is the document
Yes.
which includes Ignito within it?
That your lordship will find
I just wanted to know.
Annexure 11, page 22 of the rejoinder. Lordship will find the railway has. One second. Yes.
Ignito is there.
Your document will have.
It's not L1, L2 and railways will argue.
Allow me to submit.
I will not be able to
submit. Mr. Banerjee, allow me to submit. It's not the.
It's not.
Please,
We don't do this.
But I am trying to show you. But I am trying to show you. It's not comforting. That's
Wrong. When I'm putting a question to a DSG, let the DSG answer. If I am not satisfied with the answer of the DSG,
That's
I
right.
will definitely go to all of you.
My lord, whatever document, again, once again,
If the DSG is relying on certain documents,
Right.
certain confusions have a reason.
Yes.
Then it will be wise for-
Mr. Banerjee is not permitting anyone to speak. That's the whole problem, you know.
I know how to.
Yes, that's the whole problem, you know. It's not permitting anyone to speak except him.
No, I know how to.
my lord, once again, I'm clear. We have submitted the document in respect to the L1 and the L2. Relevant person, we are not able to submit enter 3,200 pages before the court today.
Simply.
That's why I'm one by one. Yes.
Yes, query says very specific and very particular. My specific query is that you are relying on clause 1.4 where you have named certain distinct laboratories. I do not find the name of
Right, sir.
Ignito.
Yes.
My answer to it that if there this Ignito is not Ignito.
We have an organization.
That is second
And
is
the
Atharva. The
Yes.
Atharva for another one is a paneling.
Yes.
Now, these two names are not reflected in clause 5.4. My query is that how you are treating this as a reputed laboratory.
Yes.
Do you have any explanation or any?
We have.
Sure.
Yes.
Simple. That's why you are all jumping on that.
Whatever document I have submitted to the court for perusal, It is the document in respect to they have what they have uploaded in the system in the time of omitted document.
I have
It's
not
not to the-
raised a doubt that these documents have not been uploaded.
Yes.
Have I raised a doubt? No.
No.
It is there. We
That's
treat
why one
it because
document-
the certification has come.
It is legit.
We accept and we treat the fullness.
That's why I'm thankful to my friend. He has submitted document in rejoinder Lakshmi page 22.
What is your answer?
The Lakshmi, see the letter dated annexure 11 dated 12/8/2025.
Rejoinder is there.
May I pass on this? I will come.
Rejoinder is not one.
That document, Lakshmi, see,
Yes, sir.
it is a document issued by the government of India.
No doubt.
Yes, our document. We are admitting this, this document letter dated 12/8/2005. Make the Lakshmi.
No difficulty.
Lakshmi, before that, you see the government of India, Ministry of Railway,
Oh, yes.
Research and SDR. Yes. Then like this, the subject testing of fire protection properties for coach furnishing materials as per the EN number such and such standards. This office of the EN number such as 24/6/2022. The Bhide reference number RDSO had empaneled Mr. Ignitu Lab Private Limited, Faridabad, Haryana, and Messrs. Spectro.
Analytical labs, private limited.
Then such and such Chennai,
Chennai.
for fire testing of coach furnishing materials as per EN number such and such standards. Bhide letter number MC/testing dated 24/6/2022 to cater the testing limitations of furnishing materials. The testing laboratories as per number such and such standards has been enhanced. Then such and such thing there. I say Chennai already. So on that regard, Lordship may see this Ignitu lab, this first page we have submitted before after uploading this app. This is Ignitu fire testing laboratory testing report. And Lordship this address is last line. Ignitu Private Limited. Office address, such and such, Haryana, and their number is there. The first page, this L1's first document. The second page is also testing report by the Ignitu, and it was continuing up to last page of testing. Vinay Prakash Pandey is the signatory.
Let us proceed. Yes, you need to.
Yes.
So that the Ignitu is concerned, it has been included. Okay. Since the Ignitu is L1. Who has?
Ignitu is a testing.
L1 or I2?
L1. L1 is yes.
No, can I just?
We are concerned with L1 now.
Yes, L1. Yes.
So he has submitted this Ignitu.
Yes.
Ignitu appears to have been included.
Yes.
Now, you have enhanced the standard in the parameters. Does the testing reports confirm?
Let me clarify one sentence. One, the Ignitu is not. It is
Mr. Roth,
actual
I have
aspect.
prevented Mr. Banerjee to serve.
Why am saying?
Please, let me first complete with the DSO.
That is for epoxy, not for paneling.
I what document I submit, I'm clarifying one by one, then only come to the like this man. This is the first
Whether
documents.
paneling is also under the furnishing materials.
Yes. So my lord, this what document testing Ignitu I given, that was not given by me. Number one. What was given by the L1. The next document, Lakshmi,
What?
This document in respect to paneling. Let's may come to the,
That is the first, we are not concerned with the wash basins or epoxy. Because
Yes.
you have admitted,
yes,
you have admitted that they have submitted the certificate relating to epoxy.
yes, we are not
We are simply concerned with the paneling.
paneling.
You have said that Ignito has given, Ignito is recognized in this. That's
Yes.
all. That is what your case.
Yes.
I believe you should not go further.
Yes,
Yes.
yes.
Now, let us then move to Mr. Banerjee to clarify that why Ignito should be ignored.
Yes.
Sir, before, can I just respond to that? My learned senior friend has shown page 22. I have brought this document on record. Now, please turn over the page before to page 21. I don't know what certificate has been handed over. Please turn back to page 21 once. Amendment slip 1
Yes.
is appended to the specification so and so, flooring material so and so, 2-part category of test. Now your lordship will see fire properties test as per 45545. These tests shall be repeated every 3 years. However, if the consignee or inspecting agency desires to do the type test before 3 years, the supplier should not deny the same. So this certificate that of Ignito has now been given to the tendering authority must be valid within the last 3 years. I haven't seen the document, that your lordship will just once check.
That is, it is, there.
No, your lordship will see the report if it's within from 2023 till 2026. There is, may I just have a look at it?
No, you can. Should not share.
Your lordship, there should be 2 certificates.
No. You should not share.
I will direct the affidavits to be filed to disclose it.
There are 2 types of certificates.
As far as our rates are
Under
concerned,
the RTI, we can no rates, we are not concerned with the rates.
no, even the specifications, where we are getting it.
Yes. These tests shall be repeated every 3 years.
Yes.
Regarding
Now, my lord,
the test.
it's 3 years.
What is 3 years?
So that my instructions are that for the epoxy flooring, which is serial number 5, I don't know if your lordships have been favored with what, because I don't know why 3,000 pages could not be brought in a day. If your lordship has found, because we've given all the certificates in terms of the circular at page 22. Kindly call upon the learner DSG to show the epoxy certificate in terms of serial number 5, because that is not even of any of these laboratories of page 22.
You cannot improve your case.
I'm on a.
Your conviction is straight away on the last officer was that they have also not submitted the test certificate.
That's right.
That's all.
First point.
Taking us to this particular case, because you are, is that these days should be repeated every 3 years. That is the certificate, I do not know. It should be
Valid within 3 years preceding.
preceding the date of the last submission of the bid.
Yes. Now, my first submission on that, is in respect of epoxy flooring, L1 has not given a certificate in terms of page 22 from any laboratory. Secondly, these tests are not within the last 3 years. The second bit of it is that with regard to paneling, look, I have given all the documents, and those documents on record, one after another, I'll show it to you. Yes.
So far as the paneling is concerned.
Yes. Page, well, if your lordship looks at page 60 of this rejoinder, of this rejoinder, please see.
This is which industrial quality controller.
24 minutes, please see. Impact resistance test on aluminium shall be free from so and so coating.
No, page 16 you are referring.
Yes, ma'am.
This is issued by,
Industrial Quality Controllers Testing Laboratory.
what is this? When it will recognize. It will recognize. Banner. Within 5.4.
Yes, this is because they don't.
This is for epoxy floors.
This is for epoxy. For epoxy, not for panel. My understanding is right. That's for epoxy. And for paneling,
We are looking at page 16.
yes,
That table,
yes, madam.
second table,
Yes, madam.
serial number 22.
Right,
It is very hazy.
This is fire and smoke reactive.
No, this soil. What is this? Soil resistance.
Fire and smoke. This is for epoxy, not for paneling.
Epoxy.
Epoxy is not the issue before your
No, not there, but,
Where is the paneling? Where is the paneling?
This is not for paneling. This is not for paneling.
Where is the paneling?
Yes, you're right asking. You may kindly see at the top, the interstate and the composition.
Where is the paneling?
How do you know this is? The specifications given here are not for paneling.
Page 56, physical testing, says yes. First, second, three, fourth, fifth line. Yes, Mr. Ratha is
Page
reading.
56, please have a look at. One of the distinction that they are trying to make, I'll show is clause-wise compliance. Specification of,
Where is your certificate?
this is the,
Laboratory report.
no, your lordship will just see once. Specification, I'll just show it. This is, this is a NABL accredited body
What I think can.
at the right hand top of the code. No, these test reports are later. I'm just showing how I've complied.
The test report.
Yes, I will show that. But once your lordship will look at page 56 once, then I'll take your lordship to the test report.
Yes, show us the test report.
Yes, ma'am. Page 71, please have a look at. Page 71, please see. Test results. I'm sorry, 72. I'm sorry, no, 72. 56 was by Zen. Agro Quality Control Laboratory, NABL accredited body is saying test report, name of customer, which is page 56, product specification, MMDTS 20046, sample, interiors of railway coaches, mixing ratio, weight component.
Where from your?
The sample at page 72, your lordship will find.
Yes.
Test report number at the top.
Page
7,125.
27/1/2025. Grateful.
How do you see that, this is,
Mulak, actually, I can't hear. Wait, 1 second. I'm sorry, Mulak.
panel.
Yes, I'll just show that. Mulak, this test report. So that's the distinction I'm trying to make. You know, so if you've seen the sample description here, and there is a particular MMDTS 20046. 20046, your Lordship has found product specification right under sample description. Page 72, right under the sample description.
71.
No, 72.
You are referring this.
Yes, so that is 71. Sorry, not in mine it's 70.
71.
My apologies. My apologies.
I'm grappling with it. It's from.
Mine is 72.
No.
I'm very, very sorry.
71.
Mine is actually the next page.
71.
Yes. Your Lordship will see sample description. Just under that is a product specification. MMDTS 20046.
Yes.
Now, please just once have a look at page 173 of the writ petition. Yesterday, a submission was made that for FRP, there is no certificate, nothing is required. And specific stand is, I have not given a certificate. Now, I'll dispel that down. Page 173, if your Lordship just have a look at. Please have a look at the first one. This is the issue.
No, second is the issue.
Which one?
Serial number 2 is the issue.
They will know.
Paneling.
May I just show one?
This report is pertaining to this not for paneling.
Not for
paneling. Not for paneling. This report is for paneling.
One is the issue, paneling. Let's not do this. My explain.
Paneling code is
Please have a look at serial number 1.
46303.
That is what.
Complete repair. Page 173.
That is the walls area.
Yes, because that's, your Lordship will now compare it to the affidavit. That's the specific stand in the affidavit. Now just affidavit 1. Complete repairing of existing FRP panels. Yesterday, everybody screamed and shouted, certificate not required. With water-based filters and resins. Please mark this. Supply and application of fire barrier decorative coating as per specification MMDTS 20046. Having anti-graffiti, scratch resistance and antibacterial properties, qualifying to so and so for fireworthiness, complete repair of FRP walls shall be ensured before painting, material application, MMDTS 20046. The certificate is there, affidavit done. The affidavit is that page 71 clearly, MMDTS 20046 specification. L2 and L1 will now bring me to 2. Railways, the body. Let's have a look at the railways affidavit. Now, please have a look at the railway affidavit.
Not this MMD.
L2 will not do. I have not disturbed anybody. L2 will not jump up for the just once. Sorry.
Already.
Yes.
What they say is paneling, which is ceiling area, which relates to ceiling area. Ceiling area is MDTS 463.
Yes.
Ceiling area
Yes.
is not the railways ground for my rejection. That's why I wanted to show the affidavit. Just once have a look at the affidavit. L1 and L2 will not decide why I will be rejected. The railway has come forward and given the rejection criteria. I'll read it out and not uploaded documents pertaining to panel material, which was the basis of the rejection of the petitioner. The paneling material includes FRP walls of the toilet, which form a major portion in the tendered work. The rejection is not to L2 and L1 is deciding under what I'm going to be rejected today.
No, we're not deciding.
The railway has restricted it to 1. That's the affidavit. Page 10 of the counter 305. And my certificate is there. It is based on that certificate. In the first one, I become L1. This time they want to nudge me out. Same material. The affidavit says because of walls, which is why I put my neck out yesterday and say I'll take 1 lakh rupee cost. Counter page 10. Counter of the railways, paragraph 30, running at page 10. Today L2 is very vociferous. L1 is very unhappy about how I argue in court.
I
may have a very bad style.
Please, please.
Page 10, once I'll just place it for your lordship's kind consideration. In the instant, great. In the instant tender, the petitioner has submitted the fire, smoke, and toxicity of epoxy flooring and wash bases, and not uploaded the documents pertaining to paneling material, which was the basis of rejection of the bid of the petitioner. The paneling material includes FRP walls of the toilet, which form a major portion in the work.
PPS 20046.
Yes.
Which is apparent
From my
of this
page 70.
that is 71 of the rejoinder. And that contradicts, your stand is contradicting to this paragraph 10 which he has read to you. And now you are turning it to ceiling. Ceiling is not the criteria.
Epoxy paneling materials includes wall and ceiling. It is not
Where are you
that.
stated in your counter? Where are you stated? In addition to 10, do you, can you show it?
We are confined to the materials which is required for the railway for construction.
Your counter, you speak to your counter, sir.
Yes.
Come to your counter which he has read to you.
Yes.
This paragraph, page 10. This portion, you have restricted it to walls of the toilet, that is the.
That's why specifically.
He has not published the report
Yes.
with regard to this walls of the FRP.
Who are writing place. Yes.
He has demonstrated that which relates to MMDPS 2004.
This is the different.
Demonstrated this.
Yes.
You are one of-
But yes.
So it is not the serial number 2, it is serial number 1.
Paneling is a work. After that, this next
One
person
of
will
these
come. Yes. They have filed the result. That's why yesterday I told them give them.
What
Once.
Sir, FRP related to was stated in our counter.
Yes.
He is now demonstrating that page 71, he has published this report.
Not that.
What for
That report is not pertaining to the paneling.
That's the whole
It is
issue.
the coating. The coating is different, paneling is different.
What you have stated in your counter, you just.
Yes, what we do this. Again, once again I'm reading, my lord. Once again I'm reading. In the instant tender, the petitioner has submitted the fire, smoke and toxicity of epoxy flooring and wash basin and not uploaded the documents pertaining to the paneling material, which was based on the rejection of the bid of the petitioner. We are considering that. And then this page 70 is not pertaining to paneling material.
Sir,
Yes.
next sentence, sir.
Yes, the paneling material include the FRP, fiber plastic walls of the toilet, which form the major portion in the tender work. The toilet wall are prone and prone to the fire and smoke due to the regular and frequent passenger using the
Toilet walls.
What I'm saying, clarify, my lord. We are not disputing, they have not given two certificate in respect to the fire and,
But you meant to say
yes,
that even though they have submitted this MMG TS 20046
yes,
with regard to this wall toilet,
yes.
but the ceiling also they have not given.
The paneling they are not given. Paneling they are not given. And they are consisting the flow, paneling, it is not paneling,
Sir,
it is a coating.
sir, perhaps I am communicating wrongly.
Anyway, it is a matter of study, my lord, we also not expert in this field.
You have very important counters, very specific. That this party, to walls of the toilet, he has not furnished.
This is painting. This is for paint.
Paint work.
Also, he has demonstrated. With regard to walls. Now they are saying that ceiling he has.
My lord, this production engineer is there. If you allow him, then he will.
Sir,
Yes.
I am just on your stand taking.
Yes.
When now they are saying that ceiling report is not given. Paneling regarding.
No, not like this. Ceiling and wall both. It is not that he has given two documents in pertaining to floor and this SC. He has not given the material in the paneling, my lord.
Very sad.
That is the document. What S70 they are showing to, it is not cutting. After completed putting will come. Painting. It is what happened in this case. Quality with required for the railway will be specification by the railway. If they are provided the same on specification, the price will not maybe touch what they have put it. So they want to avoid the same, they are putting all these things. L1 is whoever the L1 or whoever given certificate will go on abide by the specification or testing report given by the authority concerned. Let's see additional affidavit about. We have clarified this.
Why do your lordships are making that comparison?
Lordship will come page 13. 1-3.
Page
18 and 19.
Page 173, serial number 2, supply, fire barrier, decorative 14. That is exactly what is there as your lordship.
Let me complete. Let me come. Page 13. Let me come.
For all area. I will not argue any further, Lord.
Complete doing it. Which is system on the test data complete. Paragraph 8 and 19 will clarify, my lord. What question my lord is putting to us? That is clarify, my lord may see the additional APT page 13, paragraph 18 and 19. This is the
My lord, sir, I am to leave. Just one liberty from my lord. I have to leave. Let's leave together. My junior will take over. Maybe. No, I should have it. Mine is also at hand. I should have Bangalore. Oh, otherwise would have traveled together. Would have enjoyed the time there. Yes, yes. It's a our UCC will have situation by included my serial of which I thought of that was this son in college. He'll be quite upset if people think he is a 45-year-old son. 45 years. I'm 44. I had education voice for this. And this is the
We are happy that this FRP panels or whatever the certificates pertains to one. And you are saying that it pertains to two.
1, 2.
We are saying
One
that
and two.
you have said that includes the panel that shows that you are really referring one. But these two persons, L1 and L2 are or I would say that jumping on that it is relatable to two. What I notice, one thing, because from his document, so far as one is concerned, he has given a test laboratory report. Because I find that is the MLDTS, which is reflected, it is really reflected from their testing report. Anglo.
It is Dixon.
He has given one.
Sir,
That is for pen.
150. Sir,
That is a coating. You are talking about coating.
14. Yes.
Correct? He has given sample.
Yes.
Not that. You are saying that the paneling is coming under serial number 2 and page 173.
Yes. 1 and 2. 1 and 2.
Correct?
1 and 2. Both. 1 and 2 both, my. Because
No. 1 and 2, 4. No, then, sir, does it not require that for both the certificate, separate certificate is required to be submitted by them? I'm asking.
There is a.
No, I'm asking you both.
Yes, yes.
When you say 1 and 2 both,
Just can I
there must be a testing report separately for 1 and testing report separately for 2.
Just a minute, let's me. They are saying that whatever materials they would evolve, the same material they are utilizing the floor also. But
So that's it.
But I am asking you. 1 and 2 into different categories.
just a minute,
L1 or L2?
Assisting me.
Oh,
Don't have a confidence on a senior.
I fully have. See, 1 and 2, both by the 2 certificates required, 1 certificate.
Problem is ESK is not properly briefed. That is capability.
Although he has a fleet.
He
has a fleet of an expert dealing with it at the. So what more? That's why I wanted. Let them give.
What
They
they
have
have
some queries, let them answer.
Yes, they are clarifying. Let's me come to the page 173. Page.
I'm doing.
And that 173,
Yes.
the lordship is coming.
Serial number 1 and 2 I'm talking about.
Yes.
We are not going to order.
I am just
Tell
doing
me
my.
what does it mean?
Yes,
He says that I have submitted the certificate testing report. This is what he relies upon. You say that it is in relation to serial number 1 only. It is not in relation to a serial number 2.
yes,
If
correct.
I correctly understand.
Yes.
L1 is also jumping on that. That it is not in relation to serial number 2. Correct? Then if serial number 1 and 2 are 2 different distinct specification,
Yes, correct.
does it not require a separate testing certificate for serial number 1 and serial number 2?
There's what they are fixing on this section certificate required for serial number 2 only.
Why?
It's because they are writing the ceiling area 1 supply and fitment DGFRP of
This is
5
also appearing in
mm.
serial number 1. Same thing.
Same thing.
With different specification. Then why it is required here and why it is not required in 1?
What is your answer to
Tell me.
both are specification, TS.
Absolutely. Both talks about NDTS. And
266
Permit was technically yes, saying I'm not able to.
We have given both.
He's a production engineer, he's just
No,
like.
sir. No, sir. Why we are putting a question after looking into the document, and that is why the railway is more public.
No, that's why he's type.
What clarification?
Saying that,
Sir,
yes, saying
I'm
that.
telling you, it appears very interesting. The petitioner has submitted the FST
Yes,
for serial number 1.
yes.
That means FST can be issued for serial number 1. There are 2 things. One is it is not capable of being issued. Then there cannot be any question of issuance. If it is capable of being issued, why not you will ask for issuance of that test representative?
Well, see, why?
Why you say only 2? I will ignore 1.
And your
Pertaining to
If
1
it is
and
for both, tell me. If it is for both, then I find only for 2, not for 1. Where is that?
This he is not understanding what. Here she is saying that the L1 is given both.
Where is this? Sir, the document I have seen when you are taking the power. This MDTS. This MDTS.
We have given, railway has not submitted to your lot. We are giving two certificates.
My lord, he is saying that
Submitted to us is what?
yes, he has submitted, but he is not.
We are giving two certificates, railway has not.
My brother. Remain quiet.
Started by full file or file.
Remain quiet.
Just a minute,
Let me have a class.
My lord, according to my instruction, submitting, they have submitted the certificate, but in this page, this is not there. Because
Sir, why not? When you have given for epoxy, you have given for wash basin, you have given for paneling. Then for coating, you will not give the panel coating.
they will produce, my lord, there is no problem, we will produce. That Lordship may see, it is number one, there is a, as per the specification MMDTS 2046, that's, that certificate is not with the document.
Certificate matches. That certificate matches 20063 or whatever.
Yes, we have.
But 455, the second one.
Second number. 46303. Yes.
460.
It's not there.
First, second page.
It's not
talks
there.
About 46303.
Is there? It is there.
Not 200.
That they are not giving.
Come to the second page. Mr. DSG, come to the second page of Ignito.
Ignito.
Top
Yes.
introduction.
Introduction.
What is written? Ignito. MDTS, what is that?
46303.
Which is reflected only in serial number two.
Number 2. Yes, correct.
One.
Yes.
What about one? Yes,
What about one?
one is there, but they are not giving.
One we have, but this is not.
Try to understand. When it is both is mandatory, then both must come.
Both must come, yes, both must come.
After lunch, we can produce. That's in the.
My lord,
If it is not, we will. And secondly, now the another question. What is the effect of page 20 of the rejoinder?
Space 20 of this. Yes.
20 or 21 of the rejoinder? 21 of the. What it talks about?
And that is in 2016 notification.
What is talks about?
Yes.
Certificate when what is the effect of this 3 years repetitive certificate testing has to be done? That means the testing report is valid for a period of 3 years. It has to be retested. Is it? I wanted an answer from you. Is it that it should be within preceding 3 years? Testing report?
It is 2025, my lord. Let's see the first page.
I know.
Yes.
But
Yes.
kindly come.
Yes.
There is another catch. Come to the second page. You are referring, come to the first page. First. I know. Customer reference. Have you got that? You're the bunch.
Yes. Customer reference number
18.
Yes.
But I need a small help from my lord. I just leave with my lord permission. Lord.
Yes, you got it.
Yes.
Go at the top right hand side.
Yes.
Issuance number and a date. Issuance number and a date.
They are saying that it is a permit issued by the authority.
No, when this certificate test report is issued, this may be a customer reference. You are submitting this document. With me?
But they are given the date, my lord. That is sample booking on 22/2025. Then date started testing from 1/3/2025. The grant completion of 1/3/2025. The date of issue is 1/4/2025.
1/3.
3/4/2025. 3/4. Sorry, ma'am. 3/4.
What is this date, issue date? Where the top? Okay, sir, I got it.
Can this come by way of an affidavit?
It will come. But, anyhow.
That document we can submit.
But I'm sorry, I've been disturbing you. My flight is just 4 p.m. I take leave from you. That's all I was trying to help.
Don't miss it.
Take a help from you. Item 21 for matter.
Before your lordship,
Item 21 for matter.
before your lordship closes the matter,
Yes. Middle of your yeah.
He will be there.
Ballot, before your
Lordship
lordship,
coming at 2.
before your lordship,
Both of you can leave. Have a same flight.
before your lordship closes the matter,
I wish on both of you are absent. I wish on both of you are absent.
ballot, before your lordship closes the
One.
May I please question? Here we are the petitioner. After the we are granted the mining lease of
What?
mining lease for